Good afternoon. My name is Paul DeBolt, and I'm the chair of Venable's Government Contracts Group. I'd like to welcome you today to our first installment of our three-part post-mid-year government contracts roundup. Today, we're going to talk about some of the most important bid protest decisions from the first half of 2022. Joining me on the panel today are my colleagues, Taylor Hillman and Lindsay Reed. The next slide. So through June, it's been an interesting first 6 months in the bid protest arena. There have been two cases that have received a lot of publicity where the Court of Federal Claims issued opinions that diverged fairly dramatically from existing GAO precedent. There was also a successful argument that an agency had improperly converted a best value procurement into an LPTA and a host of other issues. I know a lot of protesters raised this conversion issue from a best value to LPTA, and I think it can be a viable argument in the proper circumstances, but the decision is noticeable because it's not often a winner. So with that, why don't we go ahead and turn to our first case. So the first case we're going to discuss today is Sabre Systems, Inc. It is B-420090.3, and it was issued on June 1st, 2022. Now, in this case, the GAO sustained a protest challenging the awardee's proposed professional employee compensation plan, where the evaluation relied on an unreasonable interpretation of the term professional employee that excluded certain categories of workers. The disappointed offeror, Sabre, protested an IDIQ contract awarded by the Department of the Navy for mission system software engineering, development, integration, testing, and in-service support for U.S. Naval Aircraft Major Defense Acquisition programs. Now, while Sabre challenged multiple elements of the agency's evaluation, the one that actually got some traction with the GAO was the allegation that the Navy failed to evaluate the awardee's total compensation plan as required by FAR Provision 52.222-46. And what Sabre alleged that the agency did incorrectly was that they had improperly excluded a large number of labor categories from its professional compensation evaluation. The solicitation required all offers to provide a total compensation plan for each proposed professional employee in accordance with 52.222-46 as part of their cost and price proposal. And just to remind everybody that 52.222-46 requires the agency to evaluate a plan to assure that it reflects a sound management approach and understanding of the contract requirements. The provision further requires the procuring agency, here the Navy, to assess the offeror's ability to provide uninterrupted high-quality work by considering the proposed professional compensation in terms of its impact upon recruiting and retention, its realism, and its consistency with the total plan for compensation. I mean, in looking at these cases, one of the things you need to keep in mind about 52.222-46 is what it's trying to do, or what the government's goal is by including this, is seeking to avoid a recompetition of service contracts that results in lowering compensation and hurting the government's ability to obtain the quality of professional services that they need. Now, in the case, the agency took the position that while Subpart D of Part 541 provided the definition for professional employees, that other subparts of Part 41 also provided definitions for other categories of employees, which the agency read to mean that each subpart of Part 541 constituted a mutually exclusive bucket of employee categories. Based on their analysis of the provision, the Navy proceeded with its evaluation of professional compensation under the FAR provision, but it excluded from its assessment a number of employees that it determined were included within the various subpart definitions for executive, administrative, or computer employees. The Navy's view was that by reading 541 in this way, that they were giving effect to all of its terms and provisions. Now, Sabre, as part of its argument, countered the agency's reading of Part 541. They claimed it was unreasonable because the categories of employees defined in Part 541 are not mutually exclusive buckets, such that such that an employee who meets the definition of a professional employee under Subpart D should not be excluded from the professional employee compensation analysis just because they also meet another definition in another category of Part 541. Ultimately, the GAO agreed with Sabre's argument. It said that the plain language of the applicable FAR provision unambiguously requires agencies to evaluate the compensation plan for all proposed employees, meeting the definition of professional employees as defined in Subpart D of Part 541. As a result, they found that here, under the agency's definition, they had only determined that a fraction of the solicitations LCATs, only 4 in total, a journeyman systems engineer, senior systems engineer, journeyman test engineer, and senior test engineer were professional employees as defined in 29 CFR Part 541. There's a discussion about how the GAO worked through its analysis, but, and I don't think we need to go into the details of that, because ultimately what the GAO found was that the agency had failed to reasonably evaluate offers proposed total compensation plans in accordance with the FAR when it excluded from its analysis certain proposed employees who met the definition of a professional employee as defined in Subpart D of Part 541, and may have also fit into other definitions within Subpart 541. So I think, a few of the takeaways that you need to remember from this case is that, number one, this clause only has to be included in solicitations for negotiated contracts when the amount is expected to exceed $750,000 and services are to be provided which will require meaningful numbers of professional employees, which isn't defined in the FAR. The other thing is that depending on the contract and your bidding strategy, you may want to ask questions, if there's a draft RFP or during an RFP's Q&A process, to either try to encourage the government to include this provision or try to encourage the government to exclude it. Just by making the argument perhaps that there aren't a meaningful number of professional employees. I think that occasionally where incumbents get in trouble is if you've had a contract for 3, 4, 5 years, your workforce has matured. And in order to keep that workforce happy, to ensure that they're going to be available for hopefully the next wind, you're not going to be able to go in and significantly reduce their pay. Whereas somebody that's not an incumbent can come in and, try to impose lower labor rates because these people could potentially be without a job. So I think there's some strategy and potentially using questions and answers to try to shape the procurement to give yourself a competitive advantage. I think the other thing is that, as you're going through the debriefing process, if this clause is in a solicitation, you certainly want to have your team prepared to ask questions around it as part of the debriefing process. Did the agency apply the clause? What labor categories were included as professional employees? What labor categories were excluded as professional employees? Because, this is going to be some of the things that you would factor into the decision about whether to file a bid protest or not. Next, we're going to turn to one of the two COFC cases I mentioned. It deals with the unavailability of key personnel, and Taylor Hillman, my colleague, is going to just walk us through that case.
Good afternoon, everyone. My name is Taylor Hillman, and I am an associate in the government contracts group here at Venable, and I'll be handling the next few cases on our list. As Paul mentioned, recently the U.S. Court of Federal Claims split from GAO precedent, holding that unless the solicitation includes a requirement that offerors update the government regarding the availability of key personnel, if one becomes unavailable after proposal submission but prior to award, that offerors are not required to provide such an update. So first up, we're going to cover the Golden IT case dated February 4th, 2022. And in that case, the awardee Spatial Front proposed an individual identified in the decision as Mr. JH as a key person. At the time of proposal submission, Mr. JH was an SFI employee, but departed prior to contract award. Golden IT alleged in its protest that SFI's proposal misrepresented Mr. JH's availability. Thus, the company's proposal should have been assigned a weakness. The court, however, concluded otherwise. Specifically, the court acknowledged that an offeror is not permitted to knowingly misrepresent a material fact in a proposal for the purpose of winning a government contract, noting that if Spatial Front had proposed Mr. JH to serve as a key personnel role while knowing that he had planned to depart the company without any intention of serving in such a role, the Golden likely would be entitled to judgment on the merits of its claim. However, the court found that the protester had not met its burden of proving that SFI had knowledge prior to proposal submission that Mr. JH intended to leave the company. Thus, there was no evidence that there was a deliberate misrepresentation by SFI. Noting that Golden's misrepresentation claim must be rejected if SFI had a reasonable basis for proposing that it would commit Mr. JH to serve as a key person in performing the BPA and call order at issue. The court also disagreed with the protesters' contentions that Spatial Front had to alert the agency to Mr. JH's unavailability because the solicitation required consent to all key personnel substitutions by the contracting officer, and also that the GAO had long held that offerors are obligated to advise agencies of material changes in proposed staffing, even after the submission of proposals. Specifically, the court noted that the requirement regarding key personnel substitutions only applied post-award as a matter of contract administration. And addressing the GAO's rule requiring offerors to alert agencies of changes in proposed staffing after proposal submission, Judge Solemson declined to follow that line of GAO decisions, concluding the GAO rule to be, quote, without basis and unfair, noting that a proposal is submitted at a point in time and is evaluated over what is often a lengthy period, noting that the court agreed that an offeror must have a reasonable basis for all facts and representations made in its proposal and may not knowingly or recklessly include false statements of material fact. A court's assessment of an offeror's knowledge of facts and representations, however, is made with respect to the point in time at which the offeror submitted its proposal. Oops, sorry. So I think one of the key takeaways from this case, while it may be exciting for certain contractors, is that Court of Federal Claims judges' opinions are not binding on each other, and they are also not binding on the GAO. So the GAO still may come out in accordance with its old line of precedent. And I think Paul had a couple other points that he'd like to make for key takeaways from this case.
Yeah, I mean, that's a good point, Taylor. And it's the Park Properties Associates versus US 120 Fed 787 and 790 where the holding is that these opinions aren't binding on the other judges. So this just could be an outlier with this one judge. You don't know if other judges are going to follow it. The other thing I think that was underscored in the opinion that was interesting was that the judge noted that Golden had the burden of proof and that throughout the case, they had never sought discovery and that the court was unwilling to order discovery sua sponte. Now, I recognize it's not common to conduct discovery in the context of a bid protest case, but it's not unheard of. It does happen. But when a case involves what the awardee knew or what the awardee attended, it's going to be important to at least try to make the argument that you're entitled to some limited discussion. And I think that, as you're dealing with in-house counsel, I think this is a good example of where, you approach this as a partnership. I think that, if you have a question as in-house counsel to your outside counsel, ask it. Sometimes you need to push them. And I don't think there's anything wrong with that, because certainly here, there could have been an opportunity to conduct some discovery and maybe win this case. But, the question wasn't asked. And the worst thing that could happen if you do ask the question is that the judge simply tells you no. So anyway, I'm sorry. Taylor, you were going to talk about discussions next, I think, right?
Yes, we were going to talk next about discussions in large DoD procurements, specifically the IAP Worldwide Services case, which actually has two relevant decisions for our purposes. So in the earlier decision, which is March 2022, IAP Worldwide Services challenged the decision of the Army on multiple bases. The issue that we're focused on today is Judge Solomson's determination that the Army's failure to engage in discussions was unjustified in light of DFARS 215-306. The court found in the earlier March 2022 decision that there was no support for the Army's determination that discussions were not needed, minus a statement in the record stating that IAP's proposal could not have been rectified with discussions, and even that statement was in and of itself conclusory. The court found the conclusory statements insufficient even under the deferential APA standard. The court also explained that the Army had turned the reasoning for discussions, quote, on its head, noting that discussions are meant to provide offerors an opportunity to address deficiencies and significant weaknesses that by definition may enhance materially the proposal's potential for award. Noting that rather than engaging in discussions to see whether IAP might improve its potential for award via the submission of an FPR, the SSA merely assumed IAP could not do so, then used that assumption to justify not engaging in discussions, which the court described as a, quote, almost textbook illustration of circular logic. In sum, the court found no facts in the record to support the determination that IAP could not alter the source selection decision if discussions had occurred, and instead based this conclusion on mere assumptions. The court made a point to explain that discussions are not required just because DFARS 215-306 governs a procurement, but that the unreasonable aspect of the decision to forego discussions here was the agency's conclusion that simply because they were optional, that the agency did not have to engage in them, disregarding the presumption for discussions set forth in DFARS 215-306. Specifically, the court noted that it does not hold that the Army lacked discretion to decline to conduct discussions here, but it did conclude only that the DFARS presumption favoring discussions must be overcome with, quote, reasoned decision-making not reflected in the administrative record at issue. The court also noted that in sum, the AR, even generously interpreted, did not demonstrate that the Army ever considered during the procurement the requirements of DFARS 215-306. Given the lack of record in the case, the court reserved the question of appropriate relief pending further briefing, at the time noting that it was unprepared to order the government to go back and redo the procurement process or to otherwise decide the question of equitable or monetary relief absent an additional factual development. IP contended that it was entitled to injunctive relief requiring the Army to apply DFARS 215-306 correctly, while the government argued that no relief should be imposed whatsoever. The court later ruled in its May 2022 decision that limited remand was appropriate without an injunction.
So I think, some of the key takeaways, Taylor, from this case, again, one of them is the Park Properties Associates. This is just one judge's opinion. And there may be other judges over at the court that don't hold this view. I mean, we highlight on the slide that this isn't a requirement for every DoD procurement. It's very specific. So it's not going to just sort of have broad applicability. And, the problem here wasn't that the agency made the wrong decision. The problem was that the agency didn't document its decision sufficiently for the court. So there is a chance that, as this plays out, the agency could go back and document its decision, and then this results in nothing more than a Pyrrhic victory. I think the other thing is that, this case also highlights that if this clause is incorporated in one of the contracts you're going after for a DoD procurement, that you're going to want to factor, and if there aren't discussions, that you're going to want to factor these into your debriefing strategy. Were discussions considered? Why didn't you hold them? I think that's especially the case where you might have benefited from them, where you didn't get all the strengths that you anticipated or something like that. Now, the agency may not answer them, but again, I think that, you just need to go in and be prepared to ask the questions that you can. Lindsay, I think that you're going to talk next about misrepresentations regarding key personnel at the GAO.
Yes, thank you, Paul, and good afternoon, everyone. Just one quick announcement before we turn to this case is the CLE code for this presentation is going to be BID 2022, and we'll repeat that again at the end for you, but it's BID 2022. Okay, turning to this case involving misrepresentations of key personnel. So here, the GAO sustained a protest alleging that the awardee misrepresented that one of its key personnel had 9 years of experience, which would have exceeded the 5-year minimum required under the solicitation. After requesting additional information from the awardee, the GAO found that the proposed individual actually only had 11 months of relevant management experience. The GAO found that this misrepresentation was a material misrepresentation because the agency relied on it when making the award decision. So as such, the GAO recommended disqualification of that awardee.
Yeah, I think that this is a hot area. I mean, we see this all the time. Taylor, Lindsay, and myself in our bid protest practice, just concerns about key personnel and their availability. I think that one of the key takeaways from this case is that it just demonstrates the risk with LinkedIn. When people are conducting a protest, they use LinkedIn to see if a person is still at the company, to verify their experience. So I think that, part of what your capture team is doing, they need to ensure that people that have LinkedIn profiles, that they're accurate and complete, because certainly people will be out there looking for them and trying to use them as part of a bid protest. The same thing goes with job openings too. I know there are a lot of companies that they may have hired their key personnel, but they still keep the job on their website is opened. And, potential protesters are going to look for that information and try to use that against you. I think it's perfectly appropriate to do that. And we certainly had situations where it was a company's practice to keep those open until the contract was awarded. And certainly if you have that policy and make that argument to the GAO, I've seen it carry the days. The other thing is that, with regard to experience, the government takes that very seriously. If they're asking for some specific level of experience, they want to see it. And, when these issues arise in the context of cases that we've handled, either as a protester or an intervener, you pull out your fingers and you count, right? Like, does this individual have the requisite level of experience? Do they have the mandated certifications? Is this set forth in the proposal? I think one of the things you want to be wary of is if your capture team tries to take double credit for anybody's work experience. I've seen situations where during the course of a single calendar year, an individual was working on 2 contracts simultaneously, a half FTE on one, a half FTE on the other. And the capture team counted that as 2 years of experience. And the GAO was like, no, it was within the context of 1 calendar year. Just because they were working on 2 contracts, you don't get to take credit for that. So, I mean, this is an area that it shouldn't be that hard, but you do see a lot of companies that continue to make mistakes, and it really is just paying attention to the details. Taylor, I think the next case that you were going to talk about was another GAO case dealing with the failure to adhere to the solicitation's terms.
Yep, that's correct. Next is the AT&T Mobility LLC GAO decision. That's B420494 regarding the agency's improper conversion of this best value procurement into an LPTA competition that Paul had mentioned at the beginning of the presentation. So in sum, the GAO sustained the protest wherein the protester had alleged that the agency failed to follow the solicitation's evaluation criteria by improperly converting the best value trade-off into an LPTA competition. AT&T Mobility LLC protested an award under a DHS solicitation for cellular communication services and equipment. The solicitation under this procurement mandated that the award would be made on a best value trade-off basis with a specific breakdown of factors and their weighting. Specifically, technical was worth 40%. The transition factor was also worth 40%, and corporate experience was worth 20%, which included the key personnel experience element. Price was to be less important than the technical factors. AT&T's total evaluated price was approximately $20 million, and Verizon's total evaluated price was approximately $18 million. The protester argued that the adjectival definition ratings set forth in the solicitation for the ratings of outstanding, satisfactory, and unsatisfactory indicated that the agency would be conducting a qualitative evaluation assessment regarding whether proposals failed to meet, met, or significantly exceeded requirements, as well as determining whether specific elements of proposals constituted strengths, weaknesses, or deficiencies. But the agency only engaged in a pass-fail analysis here, looking at whether each proposal was merely satisfactory or not. The GAO sustained the protest based on the agency's use of this pass-fail analysis, concluding that the agency had not qualitatively assessed proposals on either the technical or transition factors, thereby failing to follow the solicitation's evaluation criteria. Noting that the solicitation anticipated the use of a best value trade-off evaluation, as opposed to a selection based on a low price and technical acceptability. Evaluation of proposals is not limited to determining whether a proposal is merely technically acceptable. Rather, proposals should be further differentiated to distinguish their relative quality under each stated evaluation factor by considering the degree to which technically acceptable proposals exceed the stated minimum requirements or will better satisfy the agency's needs.
Yeah, I think, you know, this is an interesting case, you know, just simply because you don't typically win on this argument. I mean, it's frequently made, you know, we make it, other law firms make it. But I think the takeaway from this is that as you're preparing for the debriefing, when you attend a debriefing, that you need to have the people with you that really intimately know the terms of the solicitation, so that you can ask the questions about how the evaluation was conducted and look for a disconnect between what was stated in the evaluation criteria and how the government actually conducted the evaluation. Because, I mean, that's an issue that the GAO will look at. The GAO is not going to reevaluate your proposal or substitute its judgment for the judgment of the agency, but they will look to see if the agency followed the evaluation criteria that were set forth in the solicitation. You know, they're going to make sure that the government follows the process that it said it was going to follow and that it abided by applicable procurement law and regulation. And that's what they're looking for. And here, there's a disconnect between the government's award decision, which was LPTA because the pass-fail component, and what it articulated it was going to do as part of a best value trade-off. So Taylor, how much, I think the next thing we're going to talk about is the agency's discretion to cancel a solicitation, which, you know, can be very frustrating, especially if you were the awardee.
That's correct. Next, we were going to highlight Seventh Dimension LLC v. United States, 160 Fed Claims 1, 2022. So in this protest, the court sustained the protest challenging the cancellation of an SDVOSB set-aside solicitation where the agency failed to meet its obligations under FAR 15206. The Army claimed to cancel the solicitation pursuant to FAR 15206 subsection E, claiming that budget cuts had resulted in significant changes to its requirements. FAR 15206E permits the government to cancel a solicitation if it issues an amendment that changes the solicitation's requirements so much that additional offerors would have likely submitted bids if they knew of the change. FAR 15206E specifically requires that cancellation decisions be based on market research or otherwise. And the latter part of that provision is what is important for this case, the or otherwise language. The government admitted that it conducted no market research before canceling the solicitation here, asserting that FAR 15206E does not require market research. Rather, the government relied on the quote or otherwise clause, arguing that it only required a rational basis for cancellation. Essentially, the government argued that the or otherwise clause imposed no constraints on the cancellation decision beyond what reasoned judgment requires. While the court agreed that FAR 15206E does not expressly require market research per se, and does not require a contracting officer to definitively prove that there has been a cardinal change in requirements, the court ultimately found that the phrase, quote, based on market research or otherwise, unquote, means based on market research or evidence similar to market research, which may include information or data that's already in the agency's possession, or perhaps even an agency's concrete experience, etc. But some form of evidence was required. The court also found that the agency had not adequately considered whether the change in requirements was so substantial that if offerors had known about it, that additional offerors would have likely submitted offers. The Army's cancellation memorandum stated that offerors would likely view a fixed price contract more favorably than the initial IDIQ contract, but the court found this conclusory statement insufficient, concluding that the contracting officer and the government before this court point to no facts in the administrative record justifying the Army's cancellation of the solicitation pursuant to FAR 15206E.
Yeah, I mean, I think sort of what this case highlights is that while the government does have a lot of discretion in all aspects of procurement, it's not unlimited. And I think what you're seeing from these Court of Federal Claims cases is that if the government wants to use the power or authority that it has, it's going to have to document the record and take the appropriate steps to just do that. And so I think there could be, some uptick going forward in the procedural process that the government uses in exercising its discretion for protesters to question what the government's done. Here they're questioning the decision to cancel a procurement, and there wasn't enough there to satisfy the judge. In the IAP Worldwide Services, the government made a decision not to conduct discussions, which they had the ability to do, but again, the record didn't support the decision. So I think you could see some increasing pressure on the government that if it's going to exercise its discretion, that it's going to have to provide adequate documentation, so there's some sort of check and balance on that discretion. The next case we're going to talk about is Versa Integrated Solutions. And this deals with the timeliness of proposal submissions. I don't know that there's anything sort of monumental about this case, but I also think this is just one of those good teaching cases where as you're talking to your capture team, you really want to convey to them the importance of following the rules, right? Making sure the font's correct, making sure things are timely submitted, making sure your proposal's neat. I mean, all those things count, and it's always good to have some reminder of that. And I think this case is a good teaching tool. So here, the GAO denied a protest filed by Versa because the agency did not timely receive its proposal in a manner consistent with the terms of the solicitation. This is one of those two-step solicitations. Here, the RFP provided for the submission of proposals in two parts. The agency would evaluate the part one submissions first, then send a notification to offerors who submitted a timely proposal, advising them as to whether the agency recommended that they submit a proposal for part two. Part one proposals had to be submitted via email to the contract specialist, courtesy copy of the contracting officer. The deadline for part one proposals was 12 p.m. Eastern Standard Time, November 12th, 2021. In response to the request for proposals, the agency received 20 proposals. One of those 20 was not Versa. The evaluation period for the phase one concluded in mid-January. The agency sent advisory notifications to the 20 offerors the latter part of January. And then in early February, a representative from Versa contacted the agency to determine the status of the part one proposal and when it would be receiving an advisory notification. In response to that inquiry from Versa, the CO told Versa that they never received their proposal. And Versa responded and stated that, look, you guys did receive our proposal via email, but the email had been quarantined by the agency server because the email allegedly contained macro files that could contain malicious code or computer viruses and are harmful to IT environments. And then not getting it the relief that it wanted to be included or to get evaluated and perhaps move on to phase two, Versa filed its protest. Versa's position was very simple, is that the agency unreasonably rejected the proposal as late because Versa submitted its proposal prior to the deadline when it was due, and the agency had control of it. But the GAO disagreed, noting that offers duty to deliver their proposal to the proper place by the proper time. And that what was also important in this case was that the RFP included FAR 52-212-1 instructions to offers for commercial items, which provides that proposals not received by the contracting officer and contracting specialists by the exact time specified would be late and unevaluated. Now, there are some exceptions to that, but if in the context of a FAR 52-212-1 procurement, if there could be some problem on the day that your proposal is due, it could be deemed timely if you got it there by 5 p.m. the day before, but they didn't do that. So I think that, you know, sort of the takeaway from this case and others of its other similar cases is that you really do need to plan for the actual submission of the proposal. You need to plan for things going wrong. And if there's a risk that you submit the proposal the day it's due, it's a commercial items proposal, it could get caught up in the government system. You're not going to get any relief. So you may want to back it up and try to get it in, you know, by 5 p.m. the day before, so that at least you have an argument that the government should consider it. I mean, it's not guaranteed the government will consider it. You know, the contracting officer will have to determine that it wouldn't delay the acquisition. But I think you certainly put yourself in a better position. The other thing is that, you know, when proposals are due, there's nothing wrong with picking up the phone and just asking the government whether they received it or not. You know, I think that you just can't assume that everything is going to go right. And certainly here, you know, that assumption came back to haunt Versa. The next case we're going to talk about is K&K Industries, and this is another this is a timeliness protest. And it's an interesting case. The GAO dismissed the protest as untimely because it was filed more than 10 days after the agency stated that the protesters' enhanced debriefing had concluded. Now, generally, and we're talking about the timing for a timely protest versus SECO, which is a little bit different analysis. Generally, a protest must be filed within 10 days when a debriefing is held. For DoD enhanced debriefings, the 10-day period begins once the debriefing is concluded, and generally after one round of questions and answers. And in this case, the GAO said, whoa, not so fast, right? Here, the protester and the agency underwent 3 rounds of communications after award. The protester argued that each round of communications continued the debriefing, and the GAO said, no, sorry, you're wrong. That's not the rule. So what the record shows, and what the sort of the key facts here when you get to the nub are that the record shows that after it responded to the second round of questions, the agency said in its response back to K&K Industries that this concludes your written debriefing. But the agency also said that any additional questions must be submitted by December 1st, 2021. The disappointing offer, K&K, sent additional questions on November 24th. The agency responded to the questions on December 13th, and they filed their protest on the 20th. And what the GAO said, that based on those facts and the statement by the agency that this concludes your written debriefing, that the agency unequivocally concluded the debriefing after the second round of communications, and that its willingness to continue discussions after making that statement was voluntary. And the third round of discussions did not extend the time. Third round of voluntary discussions did not extend the time for filing the protest. So I sort of, thinking about this and understanding how draconian the timing rules are at the GAO, it's important to realize that an agency's voluntary responses to post debriefing questions will not extend the GAO protest deadline. Second thing I think you need to take away in determining whether a debriefing is concluded, only the agency's action can extend the debriefing. Offers generally cannot extend debriefing by cannot generally extend the debriefing by asking more questions. The other thing that was mentioned in this case, and it's important, is that the GAO recognized that it previously found that enhanced debriefing rights only entitle the offeror to one round of questions and answers as a general proposition. There may be some exceptions to that, but that's all you're guaranteed. So, when you think about this case and think about the outcome and some of the confusion that could have arisen by the way the government wrote its response to K&K Industries, if it's not clear whether the debriefing is over, ask. Okay, there's no harm in asking. They may say yes, they may say no, but at least you're not assuming that the clock hasn't started. If they don't respond or it's not clear whether the debriefing is ended, you may want to think about filing the protest sooner rather than later. As I tell Taylor and Lindsay all the time, we can redo early. If a protest is premature, we can't undo late. So, if there's any ambiguity at all, you may want to think about, going in sooner rather than later, especially if the communications aren't clear and the agency is reluctant to provide you with any level of clarification. Lindsay, I think can sort of continue with this theme of timeliness. You're going to talk about Patel for a bit.
Yes, so this case, Patel Memorial Institute, gives us a good example of timeliness issues that can arise in the context of a FAR subpart 36.6 procurement, which is for architectural and engineering services. So in this case, the protester received notice that it was not chosen as the most highly qualified offeror, but then it waited until the actual award was finalized, which was several months later, in order to file the protest. And as we know, a protest should be filed within 10 days of when the protester learns of the basis of the protest. Patel argued that it learned the basis of the protest on the date of the official award, and therefore it was timely because it filed the protest 10 days later. But the GAO disagreed because it determined that Patel should have filed the protest within 10 days of learning it was not selected as the most highly rated offeror rather than the date of the official award. Because in the GAO's opinion, Patel's protest was not a challenge to the award, but instead a challenge to the decision in selecting the most highly qualified firm. Therefore, the appropriate time to file would have been 10 days after the most highly rated firm decision and not the official award date. So this case is helpful in thinking about timeliness issues when you're in the FAR subpart 36.6 environment. Taylor, we can go to the next slide. So this case, U.S. Marine Management, Inc., sort of continues the timeliness theme and also brings up some interested party issues as well. So in this case, the protester had submitted 3 proposals and it later withdrew one of them. The agency decided that the withdrawn proposal was included in the competitive range, but the remaining 2 proposals were not within the competitive range. That firm then filed a protest which challenged the agency's evaluation of the awardee. The GAO decided that the protester was not an interested party because even if the GAO sustained that protest and recommended a reevaluation, the protester had no proposals up for consideration because remember, one was withdrawn and the other 2 were excluded from the competitive range. So therefore that protester didn't have standing or it wasn't an interested party to file the protest. And then also the GAO found that the protest was untimely because there the protester was relying on the debriefing exception to the timeliness rules, which applies to requested and required debriefings and extends that 10-day window to file the protest starting from the date of the debriefing rather than knowledge of the protest grounds. Here, however, the GAO found that the protester had withdrawn its proposal, so therefore it was not an actual offeror and was not entitled to a debriefing. And so for that reason, the debriefing exception couldn't extend the 10-day clock and the protest was untimely.
Yeah, I mean, I think about this case and like what the takeaway from it is, and it's almost, you have to be careful about what you're going to do, right? You almost have to play chess rather than checkers. I mean, here these guys had this company had 3 proposals in. They withdrew the wrong one, and even though it was still considered, they've sort of lost their ability to protest. So I think you have to be very strategic in your thinking, and if you're going to submit multiple proposals, given how this case played out, maybe you leave everything in, because what you think may be the most likely to win certainly wasn't the case here, where the 2 proposals that left in didn't even get in the competitive range. So I don't know, I think just maybe have to think a little bit more strategically on that. And then Lindsay, I think that the next thing you're going to talk about are unstated evaluation criteria, which is always an area that we try to bring up in protest. I think it's difficult to win in this area because a lot of times the GAO is going to take the position that whatever the criteria that was applied is fairly encompassed within the stated criteria. But I think this case sheds some light on when the GAO may reach a different result.
Yes, so turning to this unstated evaluation criteria issue, this is an example where the protester was successful in this argument. And the GAO sustained the protest because in this case, the SSA's evaluation findings did not have a clear nexus and were not logically encompassed by the stated evaluation criteria in the solicitation. So specifically, the SSA found that the protesters' higher ratings merely related to experience and not necessarily innovation. However, in the solicitation, there was no mention of either experience or innovation. Instead, the agency was required to consider understanding, practicality, feasibility, and reliability. So the GAO held that the decision to downgrade the protesters' proposal was unreasonable because lack of innovation had no nexus to the stated evaluation criteria.
Yep, sorry about that. Yeah, I think the things to take away from this case is, we talked earlier about making sure that you have the people that are most familiar involved with the debriefing or putting together the debriefing questions. But, so I think this is another one of those areas where you need to have the people that are intimately familiar with the RFP helping you structure the questions, taking a look at the debrief, if you receive a written debrief, participating in the debrief, because there could be a disconnect between the evaluation criteria the government said they were going to use and what they actually did use. And I think this is important because, as you're looking for things that the GAO would not find fairly encompassed, this slide provides some examples of what the evaluation criteria were, what the evaluation criteria that applied, and why those weren't deemed to be fairly encompassed by the stated evaluation criteria. So you really do want to look for, you know, a fundamental disconnect between what the agency said they were going to do and what they actually applied in the context of the procurement. And Lindsay, I think you have the honor of the last slide too, and that we're going to talk about competitive prejudice, which is important to winning any protest at the Court of Federal Claims or the GAO. So why don't you talk us through that?
Sure. So in this case, G4S Secure Integration LLC, the Court of Federal Claims denied the protest for lack of prejudice because in this case, the protester benefited from the same evaluation error that benefited the awardee. So the protester had alleged that the awardee, which was a joint venture, was ineligible for the award because it didn't register with SAM prior to proposal submission. And the members of the JV were registered on SAM, but the JV entity was not. And while the court agreed that the FAR required JVs to separately register with SAM, and meaning that the protest was meritorious, ultimately the protest was denied because the protester was also a JV that had not registered with SAM, meaning it benefited from the same error and didn't suffer any competitive prejudice. And a few takeaways from this case, one of them would be that prejudice is an essential element of every protest. Here, the agency awarded to an ineligible offeror, and the protest had merit, but that still wasn't enough to succeed where you can't prove prejudice. So that's why it's important to always consider glass house issues before raising a protest ground. Then another more practical takeaway would be to always ensure that the JV entity itself is registered on SAM and that it's insufficient for just the members to be registered, particularly where it's required under the solicitation.
No, I think that's a good point, and I think it gets to the fundamental point that you got to follow the rules. And, you know, if you're forming a new entity, it needs to actually be an entity that the government can verify. And it's funny that, but I have seen this issue come up a few more times than I would have expected. But you know, it's just a reminder that, you know, Section L is there for a reason. Read it, heed it, do what you're supposed to do when you're putting together your proposal. We're almost to the top of the hour, but we did have a couple of questions. We have one comment and one question. The first comment was, and this is in the context of a state procurements, and I think it's actually interesting, and I'm glad that it was submitted to us. The individual said that he's seeing from certain state agencies a liquidated damages requirement for changes to staff that is not pre-approved by the state. This is very new to me. The figure that he sees hovers around 25,000 liquidated damages, but you know, that's out there. I mean, I do think it's interesting. I mean, I haven't seen that in the federal space, certainly. I mean, certainly you need to coordinate the swapping of key personnel. I mean, there's a process that, you know, you can go through to get it, but it's typically contract administration. I can't recall seeing any situation where one of our clients just swapped somebody out with it without getting the approval, and you know, they got into a problem with the agency. I mean, certainly you could see it maybe in your CPARs or something like that, but I haven't seen any liquidated damage provision. I certainly haven't seen any situations where the switch resulted in a cure notice or threat of termination for default. What else do we got? So the question here is Echelon, a new position by GAO, that there were many earlier decisions that acknowledge a broad discretion of the source selection authority. Well, I think I don't think this is a new position from GAO, and I think you're right that the SSA does have a lot of authority or a lot of discretion, but at the end of the day, you know, that discretion is not unfettered. And if the government articulated a specific evaluation scheme and then it departed from it, then the GAO is going to sustain that protest. Because when you think about it, if I tell you that I'm going to evaluate you against one set of criteria, and then you write to those criteria, and then I apply another set of criteria in evaluating the proposal, I really have harmed your ability to compete in a meaningful way. Because, you know, if you would have written to the criteria that I really did want, your proposal could have been dramatically different. You know, you could have used different technologies, you could have staffed it differently, you could have priced it differently. And so I think that, you know, that's why I think that's why this case came out the way it did. And again, you know, the GAO is very deferential to the agency. They only sustain, I think the numbers drifted down to somewhere between 12 and 15% of protests get sustained now. And a lot of times when they do get sustained, it doesn't mean you're going to get a contract if you win. It means the government's going to go back and paper the record better. I don't know. Do you have any additional thoughts, Taylor or Lindsay? No? Okay, well, we're just about out of time. I do want to thank everybody joining us for today. I hope you found the presentation informative, and certainly if you have any questions, our contact information is at the back of the presentation. And I hope you'll join us for the remaining two webinars we have coming up over the next couple of weeks. We're going to deal with claims issues and compliance issues. And again, I appreciate everybody taking the time to do this. We just got a question about whether the slides will be available. I don't know. I'll defer to the marketing team, but my hunch is they are. And I just got a big old yes in the chat box. So yes, the slides will be available. Okay. Well, I hope
one more thing. We just wanted to note again that the CLE code is BID 2022. That's BID 2022.
Thank you, Taylor. I would have forgotten that. All right. Well, thanks again, everybody, for taking the time to listen to us. And we hope you have a good rest of your week. Take care. Be well.